After the critical period and Shays' Rebellion, the elites of the states realized that they had a real need to change the national government to make it more responsive, and that is what excuse me, that is what we're going to talk about next. The development of the Constitution, the body of the Constitution, and also in this Unit 1, Part 2, we're going to talk about federalism and explain what that means. So all the different states convened a constitutional convention. Okay, it means just groups of elected or appointed leaders from each of the states got together for, and this is important, the sole and express purpose of revising the Articles of Confederation. The sole and express purpose of revising the Articles of Confederation. Now, revise means change or adjust or tweak. What it does not mean is throwing them away and starting over again. But that's really what happened. But anyway, May 1787 debate begins on the new Constitution, and it's a contentious debate. There's deep-seated differences between the different states as to what is the best form of government. Uh, but at the very beginning, Virginia, which generally represents the interests of the larger states, calls for an entirely new government. They believe that first of all, that the government is not responsive and can't be fixed. I mean, it's just it's so weak that we need to start from scratch with a whole new framework. Uh, and New Jersey calls for a revision of the articles because they like the way it's structured at the base of it, but they think it could be adjusted. And basically, Virginia represents the interests of the larger states, the most populous states, the wealthiest states. New Jersey represents the interests of the smaller states. And the main point here is representation. If you remember, we talked earlier about how each state has a single vote when it comes to passing laws under the Articles. That means New Jersey and the smaller states uh, have um, much better representation. Well, not really much better representation, but they have influence that's greater than their size and their population and their wealth. Whereas states like Virginia, New York, and Massachusetts, while they offer much more to the economy, they have more people, they are larger states, their influence is no more than Rhode Island, which is the smallest state. So they feel that's not fair. They feel that representation should equate to each state's influence and how much money they bring into how much taxes they pay, how much they produce economically, and how many people they have. So that's the main difference. So the Virginia Plan, as it will be called, was promoted by James Madison, who is also called the father of our Constitution, one of the more underrated minds of the Constitutional Convention. Uh, Madison, with his Virginia Plan, called for a bicameral legislature. That means a two-bodied, two-house legislature. Uh, and it would consist of the lower chamber, which would be called later the House of Representatives, and these members would be chosen by popular election. Okay, the people would choose the members of the lower chamber, and the number of members of the legislature that each state had in the national legislature would be based on population. So it'd be proportional representation, meaning whatever proportion of the population you had in a state, of the national population you had in the state, that's the proportion of representatives you would have in the legislature. So the upper chamber, according to Madison, should be chosen by the lower chamber from state legislature nominees. So the upper chamber would be out of the hands of the masses. The lower chamber would be chosen by the elected by the masses. The upper chamber would be chosen by the lower chamber that was elected by the masses, but they could only choose from nominees selected from the state legislatures, those legislators that were elected by to their state legislature, to the Congress of their each individual states. There would be a single executive chosen by the legislature. Okay, so the president, which is the executive, would be chosen by the legislature, not by the masses. And then the judicial branch, it would be superior to the supreme. The judiciary, the national judiciary that would be created under the Virginia plan, would be supreme. It would be the supreme law of the land, and it would be a Supreme Court with inferior courts. Now, New Jersey plan, which was promoted by William Patterson, called for a single unicameral legislature, just like the legislature that under the Articles of Confederation, with equal representation, just like under the Articles of Confederation. Uh, but because of the problems that had arisen under the Articles, additional powers could be given to Congress, according to Patterson, to make Congress work. Powers to tax and actually enforce tax collection, which was a major problem of the under the Articles. Uh, Power to regulate interstate commerce, to regulate trade, and of course the power to raise an army and provide security to the nation. These powers would be added to the existing powers of the legislature as they are under the Articles of Confederation. Uh, According to the New Jersey plan, he called for a plural executive, multiple members of the executive. I guess you might call it an executive council of probably three people. And my guess, and I don't know this for sure, but my guess probably is that they envisioned an executive council serving as the presidential um, council from based on the three different members from different parts of the country. You have somebody that represents the southern interests, somebody that represents the middle state interests, somebody that represents New England. And also he called for a court system, which included a Supreme Court. So both Virginia and New Jersey plan recognized the need for three branches of government, which we didn't have under the Articles. We only had the one legislature, but both are calling for some sort of an executive as well as a judicial branch of the government. So after all the debate, and there was a lot of intense, angry debate, um, the two sides came together and did something that our current national government seems to find it very difficult to do, and that is they compromised. And if we live in a democracy, the whole all democracy is based on compromise, because the whole point of a democracy is that all interests are represented. The people, no matter what your background, your religion, economic status, uh, whatever, your interests should be represented in government, and so everybody needs to have a voice, and therefore you must always compromise. Uh, so the Great Compromise, as it was called, is the compromise between the Virginia plan and the New Jersey plan. First of all, it's also called the Connecticut Compromise. First of all, it will consist of a bicameral legislature. So the legislative body, or the body that will make the laws, will be bicameral. And that means it will have two bodies, two houses. The House of Representatives, which would be uh, based on population, proportional representation. The more people you have in a state, the more representatives you will have in the legislature. So that's one house of Congress. The other house, so that the House of Representatives, in that body of Congress, the Virginia and Madison get what they want. Then you have the Senate, which is the second body of Congress. It will consist of equal representation. Each state will have the same number of senators, regardless of their size, regardless of their population. And so that is a win for the small states like New Jersey and Rhode Island. The executive will be chosen by an electoral college, which we'll talk about later in the semester. But it is not the masses that in the end finally choose the president. It will be something called the electoral college. In the case of a tie in the electoral college, the House of Representatives will choose the president. The president will serve a four-year term with no term limits, and the president may be removed um, through a process called impeachment, which we'll talk about later. Now, there was another divisive issue at the Constitutional Convention, that sprung up after the determination that the House of Representatives would be based on population, and that was the issues of slaves and how they would be counted for those purposes. If you think about it, the southern states with all their many slaves, and many of them had they had a larger slave population than they had a free population. Um, Many those states were like ecstatic because they were thinking, yes, we can count our slaves for purposes of representation, and if they were able to do that, they would have had a majority in the House of Representatives. The slave states would have. Well, the northern states vehemently resisted this idea that you could count slaves. They said, well, you treat these people as property. They have no citizenship rights, uh, and you treat them as property. So how can you claim them to be counted as citizens? So this was a division that was created, and they also here came to a compromise. Slaves would be counted as three-fifths of a person for determining representation in the House of Representatives. So for every five slaves you had, you could count three for purposes of representation. Now, this gave the southern states and the slave states uh, more representation in the House of Representatives than they would have had if they couldn't have counted any of their slaves. But it did not. This system of counting did not allow them to have a majority in the House of Representatives like they would have had if they would have been able to count each one of their slaves. But it was another form of compromise. So now let's look at the basic principles of our Constitution. What are the fundamental ideas that it's founded on? First, republicanism. Republican. It has nothing to do with the Republican Party. It's just the term that our nation is a republic, which means our leaders are chosen through a process of indirect democracy or representative democracy. The people, get to choose those that are going to make the laws. Of course, we're not direct democracy, which means we don't all, as citizens, vote on every law, but we do have the power to choose those that make the laws and hold them accountable. So republicanism is a core principle. Federalism, the idea of sharing powers and of both the state and the national government having sovereignty in their own right. So the states and the national government share power. Neither has absolute power over the other, and this is an important checks and balances principle. Um, Separation of powers, spreading power out amongst the government. This is an attempt to prevent one person or just a few persons from taking absolute tyrannical control of the government. So you spread the power out. You have a lawmaking branch of government, which is the legislature. You have a law enforcing branch of government, which is the executive branch. You have the law interpreting uh, branch of government, which defines what the law means. That's the judiciary, the judicial branch. You cannot be a member of more than one of these at the same time. So that prevents somebody from making the laws, enforcing the laws, and punishing. You know, it keeps one person from being able to do all three jobs. Then that's the definition of tyranny, when you have somebody that can do all three, like a dictator. But but anyways, you separate the powers, uh, and all the different levers of government are in different hands. And then finally, checks and balances. Uh, each one of these branches of government, the legislative, the executive, and the judiciary, each keeps an eye on the other. Each watches the other. Uh, and this next graphic will kind of show some examples of that. Now we're not going to go through each of these. You can look at them later, but just as an example, the arrows follow from one to the other. If you look at the executive, the president, and the arrow pointing to um, the judiciary or the courts, the president can appoint federal judges. That gives him power over the judiciary. He can grant pardons and reprieves, meaning he can override in some ways actions of the judiciary. Also, you'll see the president, he can veto legislation If you see the other arrow there, he can call the legislature into special session. He can propose bills. He acts as commander in chief. These are powers that he has that can limit the powers of the legislature. Now, the legislature, if you'll see that picture and then move upward and the arrow pointing to the president, uh, can override presidential vetoes. Of course, they can override presidential vetoes, impeach the president, remove the president, propose amendments to the Constitution, declare war. While the president's commander in chief, only Congress can declare war. And so, there's just, in the judiciary basically has maybe the most power as far as in the checks and balances system, because they can declare any act of Congress or any act of the president unconstitutional, and therefore, at least theoretically nullifying their actions. So, so it's this system was put in place to prevent neither the president, the legislature, or the courts from being uh, too powerful. Now let's take a look at the actual Constitution as it was created at the Constitutional Convention. Article 1, which is basically the Constitution, is divided up into separate articles. Article 1 explains the legislature. It lists the qualifications for office in both the House and the Senate, the terms of office for both the House and the Senate, the method of selection, and it also calls for a census to be administered. And we'll talk about the reasons for that later, but it's basically based upon the need to know where everybody lives. In a census, you count where everybody lives, and you need to know where everybody lives if you're going to base representation on population of each state. Also lists the enumerated powers given to the legislature by the Constitution. Enumerated basically means listed, spelled out clearly, so there's no question or ambiguity with regard to what powers the legislature has. But there is also something that basically gives the legislature more power, or the ability to garner more power than in the actual enumerated powers. And that is the necessary and proper clause. And the necessary and proper clause basically states that Congress may make any laws that are necessary and proper for carrying out the enumerated powers. Of course, the enumerated powers are the listed powers, things like declare war, the ability to tax, regulate interstate commerce. And the necessary and proper clause basically gives the Congress power to make any laws that are necessary and proper to allow them to regulate commerce, allow them to tax, allow them to raise an army or declare war. And basically, the necessary and proper clause gives Congress implied powers. Implied means that they're not necessarily listed, they're not necessarily obvious, but it's just understood that Congress needs these powers. It's implied. And we'll talk more about the necessary and proper clause, I think, when we talk about federalism. Now, Article 2 covers the executive branch, lists the terms of office, qualifications for office, discusses the Electoral College and how that works, and offers a method of removal and replacement for the president. Of course, we're going to talk about this semester, we're going to have to spend a whole chapter on the legislature and a whole chapter on the executive, so we'll go in depth later on in the semester on these concepts of terms of office, qualifications, etc. Uh, Enumerated powers given to the executive in the Constitution include commander-in-chief, the ability to negotiate treaties, although most treaties are negotiated in the name of the president by the State Department or Secretary of State. And then maybe one of the most important and underrated powers that the executive has is his appointment power, the ability to appoint people to offices. People, most everybody in the executive branch is appointed except the president and the vice president. And so that means the president gets to appoint all those working for him. That means those people must be loyal to him and and the president must approve of the job that they're doing, and the or they can be removed from office. This is in contrast to the Texas executive, where the governor is elected, but most all of the other members of the executive branch are elected separately. Uh, so the governor doesn't have great power and influence over those other members of his executive branch because uh, they're not accountable to him. But if you have been appointed to an office by the president, then you are accountable to that president, and you're more likely to do what the president wants. So there's huge power in this ability to uh, appoint people to office. And then the Constitution also states that the president must give a State of the Union report, which initially it was just George Washington would, send a document to Congress, reporting on the state of the union, how we're doing as a nation. But in modern times, it has become a television event where the president stands before Congress and gives a speech explaining the state of the union and also laying out his plan for the future. Also has a take care clause for the executive that the legislature makes the laws and the executive or the president carries out the laws. So the take care clause basically says that the president must take care to faithfully carry out the laws of Congress, basically meaning that he must carry out the laws of Congress in the spirit in which they were intended and not try to manipulate the laws in such a way that Congress did not intend. Article 3 talks about the judicial branch and the judiciary. It establishes the Supreme Court of the United States and defines its jurisdiction. Jurisdiction is basically the kinds of cases that the courts can hear. Uh, in Article 3, that's really all that is established is the Supreme Court. The Constitution under Article 3 gives Congress the power to establish lower federal courts. Of course, the members of the Constitutional Convention knew that the country would grow over time, and by giving Congress the power to establish the lower federal courts and determine how many there would be, it allowed the excuse me, it allowed the judicial branch to grow and the courts to grow without having to change the Constitution each time. Because if the Constitution stated that there was, for instance, the Supreme Court and three lower federal courts, and future and more lower federal courts were needed to be added, since the Constitution said three lower courts, you would have to change the Constitution each time you changed the number of federal courts. But by giving Congress that power, that was a very smart thing to do to prevent continuous changing of the Constitution. The judicial branch will hear federal disputes and disputes between states. Uh, the judicial branch, if you remember the Supreme Court or the federal courts, you have a lifetime appointment with good behavior, is how it is stated, a lifetime appointment with good behavior. And there's some controversy in some people's minds about, lifetime appointments for judge. I, for one, am in favor of lifetime appointments for judges. And we'll talk more about that when we talk about the judiciary. And then one of the most fascinating things I find about the Constitution and how they address the judicial branch is that there are no qualifications listed to be a member of the Supreme Court. No citizen qualifications, no age qualifications, no education qualifications. You don't even have to be a lawyer. There are no qualifications listed. But the process of choosing the judges kind of weeds out the ones that aren't qualified, and we'll talk about that when we talk about the chapter on the judicial branch. Article 4, full faith and credit clause and admitting new states. The full faith and credit clause basically states that each state must honor and respect the judicial proceedings and documents of other states. Things like driver's licenses and marriage licenses, you don't have to change. Um, you don't have to get remarried every time you move to a different state, because every state gives full faith and credit to the marriage licenses of of the other states. Article 5 talks about amending the Constitution. We'll touch on that in just a second. Article 6 has a supremacy clause, which basically says the Constitution is the supreme law of the land, that there are no other laws that supersede the U.S. Constitution. And Article 6 also lists that states that there is no religious test for holding office. We're always all familiar with, the First Amendment that talks about freedom of religion, Establishment Clause, and the Free Exercise Clause of religion, which we'll talk about later in the semester. But also, freedom of religion is in separation of religion from government is stated in the Sixth Amendment when they state that no religious test shall be given to hold any office under the United States. Article 7 talks about ratification of this very Constitution, because this is just the document. It hasn't been ratified yet as they are writing it. So Article 7 says if 9 of the 13 states ratify the Constitution, then it will then become the law of the land. Now, the amendment process, if you're going to change the Constitution or amend the Constitution, there are two ways of proposing an amendment and two ways to ratify an amendment. The first way to propose is a two-thirds vote of both houses of Congress. That is the way most all amendments have been proposed. Or you could do a national convention called by Congress on the request of two-thirds of the states. Um, Ratification, approval by state legislators of three-fourths of the states. So Texas, the legislature in Austin would be one of those states that legislatures that would be charged with approving or ratifying a constitutional amendment, or approval by ratifying conventions in three-fourths of the states. So there are two ways to propose and two ways to ratify. The most common process, of course, is two-thirds of votes of both houses of Congress to propose, and then approval of the state legislatures to ratify. Now, the ratification debate, basically, this idea that they must approve this Constitution or ratify this Constitution, came down to a division between two different groups. One, the Federalists, who supported the Constitution as it was written, and then the Anti-Federalists, who didn't necessarily like the Constitution as it was written, and demanded more protections, more freedoms, and protections for the states and the individuals against a strong national government, because the new Constitution gives the national government much, much more power than it had under the Articles of Confederation, and the Anti-Federalists feared this. So who were these Federalists and Anti-Federalists? Well, the Federalists were property owners, the landed rich, merchants of the Northeast and Middle Atlantic states. The Anti-Federalists tended to be small farmers, shopkeepers, and laborers, although there were some plantation owners and wealthier people like um, uh, Jefferson and Madison were wealthy in their own right and large plantation owners, but they also were Anti-Federalists. Their political philosophies: Federalists were elitists. They saw themselves and those of their class, the elite class, the educated class, as most fit to govern. Others were to be governed. So, in a lot of ways, they felt like there were some people were better than others, and those people needed to be the leaders, those that govern. The Anti-Federalists believed in the decency of the common man and participatory democracy. They believed that the masses could govern themselves. They viewed elites as corrupt, and they sought greater protection for individual rights. Type of government favored, of course, the Federalists, because they supported this new Constitution, favored a powerful central government, two-house legislature, and removing the masses from the process of governing. Uh, they distrusted the masses. They saw them as only seeking their own selfish, small interests, not looking at the big picture. Of course, by distrusting the masses, that shows in the fact that really, under the Constitution, the only entity that is elected directly by the people are members of the House of Representatives. Everybody else, there are filters to prevent the masses from choosing them directly. The Anti-Federalists wanted stronger state governments closer to the people, smaller electoral districts to make The representatives more accountable, frequent elections, referendum and recall, which allowed the masses to determine policy, um, and alliances. In general, the Federalists were pro-British and anti-French, and this will play a big part when it comes to the French Revolution. Pro-British and anti-French, and the anti-Federalists tended to be anti-British and pro-French. Now, the debate over the ratification of the Constitution basically centered around competing essays published in newspapers throughout the states, uh, arguing one way or the other, whether the Federalists arguing for ratification of the Constitution, the Anti-Federalists um, arguing against. In the end, history has told us that the Federalists, of course, won, and their Federalist Papers, a list of 85 essays that were published across the country, trying to explain how the Constitution would work, why it would prevent tyranny, all these things, why it would prevent factions from developing and taking over government, describing the separation of powers. These were the most persuasive, and to this day, they're the very best documents for understanding what the Constitution means, what the purpose of it was, why it was structured and the way it was, and why different items were put into the Constitution. So, just for our purposes today, I hear people all the time on television talking about, well, this is what the Constitution means, or we're not following the Constitution because we're doing this or that. Well, most of them don't know what they're talking about, and if they really wanted to know what the Constitution means, they would just read the Federalist Papers, and it would explain it clearly. The Federalist Papers were written by Alexander Hamilton, James Madison, and John Jay. The majority of them, of the papers or essays, were written by Hamilton and Madison. Jay got sick after writing a few of them. They were published in a pseudonym under Publius. Uh, the Anti-Federalists, they wrote their essays and they tried to make their arguments, but they were not as persuasive. Uh, that their arguments that this would be a tyrannical national government, that it would have the potential to strip away state and individual rights, wasn't as persuasive. But they finally got the Federalists finally got the ninth state, New Hampshire, to ratify on June 21st, 1788. So that's the official date that that the Constitution was ratified. But there were still four states, of course, that had not ratified the Constitution: New York, Virginia, North Carolina, and Rhode Island. And their holdouts, especially New York and Virginia, which were two of the largest, wealthiest, most important states, you really couldn't have a legitimate constitution if you did not have those two major states involved. Uh, and one of the arguments for not ratifying it was there was not enough protections, as I mentioned before, for personal freedoms and state liberties. And so, to alleviate that problem, the Bill of Rights was added. The Bill of Rights consists of the first 10 amendments to the U.S. Constitution, and it was adopted into the Constitution in 1790. Uh, we'll do a whole chapter on the Bill of Rights when we talk about civil liberties, but just know that these were uh, amendments placed into the Constitution that protected the rights of individuals, especially individuals, but also the states. Things like freedom of speech, freedom of the press, the right to a jury trial, those things uh, cannot be infringed upon. This is a graphic that shows the ratification and, in what order that the states ratified the new Constitution. Delaware was first. Some of the states, like Delaware, it was unanimous, and wasn't even really a debate at all. Other states, it was a very close vote. States like Massachusetts, states like Rhode Island at the very end, New York, Virginia, those holdout states had very close votes. But it does show that everybody was not completely on board with the new Constitution at the time that it was ratified. This is just a quick summary of the freedoms guaranteed by the Bill of Rights, the First Amendment, freedom of religion, establishment clause, free exercise clause, freedom of speech, press, assembly, and petition. Second Amendment, the right to bear arms. Third Amendment, which isn't really relevant anymore, but housing and quartering soldiers in times of peace. Fourth Amendment, protections against unreasonable searches and seizures, which is a controversial one now, with the USA Patriot Act and NSA spying revelations that have come about recently. Fifth Amendment, grand juries, um, double jeopardy, self-incrimination, pleading the fifth. Uh, and then Sixth Amendment, speedy and public trials, impartial juries, the right to face your accuser, and the right for it to have a lawyer. Uh, Seventh Amendment guarantees the right to jury trial in civil cases. Eighth Amendment prohibits excessive bail and cruel and unusual punishment. Ninth Amendment mandates that those rights not explicitly listed in the Constitution are reserved to the people. Uh, and Tenth Amendment mandates that those powers not delegated to the national government are retained by the states and the people. Now we're going to talk about one of those foundational principles that I had mentioned earlier. One of those foundational principles of our Constitution, and that is federalism, or the sharing of power between state and national governments. Okay, so let's get get a definition out of the way first. Federalism is a system of government that divides power between the national or central governments. It can be called a central government, and the state or regional governments, smaller geographic areas than the national geographic area. So, a system of government that divides power between the national government and the state governments. Both are sovereign in certain areas. Both derive their powers from the people. Neither can abolish the other without the other's consent in a federal system. Neither can change or alter the other without the other's consent. So the national government cannot, decide that it thinks that Mississippi, we've just had enough of it, we want to get rid of it, and can't do that because Mississippi is sovereign in its own right. Um, the national government can't divide Texas up into four different states if it wanted to. It would have to do it with the approval of Texas. So anyway, each has their own powers, and we're going to talk about those powers. But compared to what? If federalism is a system of shared government and shared power, uh, how does it compare to other types of government? I guess that's a good question. Well, let's compare it to Confederation. Remember the Articles of Confederation? That was our first government that we had that was established upon declaring independence. Well, in that type of government, the states are the only sovereign entity. That means the states are the highest power. The states, no one can. There's no higher authority over each of the individual states in a confederation. And in a confederation, the states establish and create the national government and give the national government all the powers that it has. And because they give all those powers, they can take all those powers away. Under a confederation, the states can alter or abolish the national government as they see fit without the approval of the national government. So confederation as compared to federalism. Now, what is a unitary government as compared to federalism? Well, as I mentioned, in federalism, the state and the national governments are both sovereign in their own right. In a confederation, the states are the only sovereign entity. Well, in a unitary system, unitary meaning one, there's only one sovereign entity, and that is the national government. The national government may create, abolish, or alter any of the state entities, any of the state governments. All power that state governments have is delegated downward from the unitary government. So the unitary government is the only sovereign entity in a unitary system. And this is just a little chart showing the difference between a unitary government and a confederation. And basically, the arrows are what really explain the differences. Um, the arrows represent the flow of decision making and the flow of resources. So the flow of resources go from local to national in the confederation or central, and in a unitary form of government, the flow of decisions and resources comes out of the central government and flows downward to the state and local governments. Now, federalism can be really divided up as far as the power arrangements. Who has what power? I guess is the biggest question with federalism. Does the national government have power, and what powers? Well, what powers do the national government have, and what powers do the states have, and then maybe we have to think about what powers both of them have. And so let's look at some terms that help us understand that. First, enumerated powers. Enumerated powers, as I mentioned earlier, are specifically granted to the federal government. Enumerated powers are specifically granted to the federal government. Reserve powers are specifically granted to the states. So basically, we start with the federal government and we say, this is what the federal government can do. These are the enumerated powers. And then after that is taken care of and that is laid out, then we say, okay, these are powers that are reserved to the states. Over and above, it shows the priority of the national government, but it also respects the power of the states. So reserve powers are specifically granted to the states. Concurrent powers are shared jointly by federal and state governments. These are powers that both of them have. Okay, these are powers that both the federal government and the state governments have, and we're going to talk about these different powers. And then prohibited powers are denied to either or both levels of government. Prohibited, obviously, means you can't do it. So if there are prohibited powers, that means the state and or the federal government cannot do certain things, and those are listed in the Constitution. So reserve powers of the national government. These include coining money. Only the national government may produce and manage a currency or a form of payment. You can't have 50 different state currencies out there, 50 different forms of money. That would be confusing and very unworkable. So only the national government may coin money. Only the national government can conduct foreign relations, okay? Make treaties, declare war, all those things. So anything that deals with other nations, only the federal government has that power. You can't have 50 different treaties with Canada or Mexico, with each state, negotiating their own treaties. Uh, Only the national government can regulate interstate commerce. That is commerce between the states, trade between Oklahoma and Texas, or New York and Pennsylvania. Uh, the national government provides for an army and navy. Okay, they they are. It is their job, the national government's job, to ensure protection. Only the national government, and specifically uh, the legislature, the U.S. legislature, can declare war, and only the national government can conduct war. Of course, the states have a national. Each state has a state national guard, but those are not independent. They fall under the auspices of the national government and the U.S. Army and the U.S. Navy, and so only the national government can declare war and can actually conduct the war. Of course, Congress declares the war, and the president, as commander in chief, conducts the war. Only the national government may establish a national court system. Of course, each state, well, always remember this, each state has their own separate court system. Uh, and most cases are heard in those state courts, but only the U.S. government can establish a national court system that crosses state boundaries. And of course, we talked about the necessary and proper clause. Congress can make laws necessary and proper in order to carry out the enumerated powers that they're given. Now, state powers or reserve powers. States manage and dictate election rules. I know most people don't realize this, but when we go vote in the state of Texas is the determining decision maker with regard to how the elections are held, what kind of ballots are used, the rules for getting on the ballots, party rules. These are state powers. Also, a reserved power to the state is to ratify amendments to the U.S. Constitution. As we mentioned before, it can be either done by the legislature or state conventions. But no power, excuse me, no amendment can be added to the Constitution without ratification by the states. The states are charged with handling, making laws regarding health, safety, and morals. Most, laws, if you break a law, most laws that you break are state laws. You know, laws against theft, laws against murder, laws against speeding, uh, drinking age laws. All those things are determined by the states. The states have the power to establish local governments. Local governments are not sovereign like the states and the federal government are. The state and the national government. The state and the national government, nobody can alter or abolish them without approval of the state or national government. Though local governments, though, are chartered by the state and only exist because the state lets them exist. Um, and then public schools. Uh, Public schools are established the um, by the states, and historically, the states have determined, and of course the local school districts have determined um, qualifications for teachers, the requirements for graduation, and all of these sorts of things. But of course, recently, since 2001 and George W. Bush's No Child Left Behind policy, uh, that power has been basically taken away by the federal government, the national government, and now we are required to do standardized testing and uh, and things like that. So the national government is now taken over in a lot of ways, determining the qualifications for graduation. And as I mentioned before, there are also concurrent powers. These are powers that both the state and the national government have. Uh, Tax, borrow money. Both the national government and the state governments, as well as local governments, have the ability to tax you. Of course, if you have a job, you pay federal income tax, which is tax that goes to the national government to help run the government. We also pay state sales tax here in Texas, and local sales tax. Also we pay property taxes too, usually local property taxes. So you're being taxed at all levels of government. But that's how governments function, and that's how governments provide services, is by the money raised through taxation. Now, Texas, uh, and there's good or bad in this. Texas does not have a state income tax. So we pay less overall in taxes than most other states. But of course, if you know anything about Texas government, we provide fewer services, and we provide less money for a lot of uh, services that other states provide more money for, including education and services like that. But Texas does not have a state income tax. Uh, uh, Concurrent powers also include establishing courts. There's a federal court system or a national court system, as well as state courts and local courts. Both can make laws. You have a national legislature and a state legislature, and they both make laws and enforce laws. You have a national executive, president, and all the agencies under him, and then the governor, uh, the executive of Texas, with all the agencies in the executive branch of Texas who enforce the laws. Um, Also, both state and national governments may charter banks and corporations, meaning allow them to exist, give them the right to exist, and both the national government and the state government may use their power of what's called eminent domain, and that is the power to take private property for public purpose with just compensation. So if there's land that the national government or the state government wants to use to, for instance, build a highway, or to expand an easement or a right of way, or whatever, for whatever reason, they can force the owners of that property to sell their property to the government. Now they have to give them just compensation, which means fair market value at least. But it is a huge power that is resented by many landowners who have been a victim of the government's power of eminent domain. And then there are prohibited powers. Okay, prohibited powers. The states, and these are a little bit redundant because they repeat some earlier things that are mentioned as far as the enumerated or reserved powers. States may not enter into treaties with other nations or other states. States may not coin money, and states may not impair obligation of contracts. Meaning that if there is a fair legal contract, binding contract between two people or two corporations or a person in a corporation, or whatever, the states cannot just arbitrarily void that contract. National government cannot favor one state over another in commerce, cannot lay duties on exports from states. So the national government can't like tax one state and not another, uh, which they don't tax anyway. And they also cannot lay duties or tariffs on exports from the states. Now, the national government can lay duties or taxes or tariffs on imports. Anything coming into the nation, they can place a tariff on it, and they've done that many, many times throughout our history, taxing imports in order to encourage domestic industrial production. But they cannot lay duties on exports from states. Neither can issue bills of attainder. The state or national government can't issue bills of attainder, which are basically legislative punishments or legislative convictions. Uh, you can't. The legislature can't declare somebody guilty and penalize them. That's a bill of attainder. And neither can pass ex post facto laws, which are basically after the fact laws. You can't charge somebody. Well, you can't make a law retroactive and then enforce it retroactively. So you can't arrest somebody for doing something when it wasn't illegal when they did it, but it became illegal later. Some important points in the Constitution with regard to the federalism or and relations among the states. The full faith and credit clause, which I mentioned before, in Article 4, basically judicial decrees and contracts made in one state will be binding and enforceable in another state, in any other state. And this brings up the kind of the modern debate over gay marriage, because basically what states like Texas and many other states have declared through either through legislative acts or through constitutional amendments that marriage is only defined as between a man and a woman, while there are other states in the nation that state that gay people can get married, and that is a perfectly legal right in their state, and that creates a conflict with the full faith and credit clause, which basically says judicial decrees and contracts made in one state will be binding and enforceable in another state. So if a gay couple gets married in Vermont and they one of them gets a job transfer to Texas and they move to Texas, the question becomes, are they married in Texas? Well, the state constitution of Texas says no, but the full faith and credit clause says yes. Texas must honor Vermont's judicial decrees and contracts. So, but anyway, that this is a constitutional question that will end up in the Supreme Court for sure. Privileges and immunities clause: citizens of each state are afforded the same rights as citizens of all other states. Meaning you can't have, to a certain extent, you can't have separate laws for people of different states. But you can. There are certain instances that you can treat citizens of different states differently, such as in tuition. You can charge them out-of-state tuition, um, and you can have them maybe you can force them to be licensed in certain fields, like medical field or uh, as lawyers, because Texas law is different. in some respects than, say, California law or Colorado law. Extradition clause, Article 4, requires states to extradite or return criminals to states where they have been convicted or to stand trial. If I commit a crime here in Texas and run off to New York, and the people in New York, they arrest me for another crime, and they find out that I'm wanted for a crime here in Texas, if Texas requests my return to Texas to try me in that in their courts, then New York has to do it. And then interstate compacts are contracts between states with congressional approval. Once again, states can't enter into treaties with each other, but there are certain types of contracts between states that, if Congress approves of it, can be only applied to the 2 or 3 states, or however many states are part of the compact. Um, Now let's take a look at the evolution of federalism. Federalism has changed dramatically or over our history as a country, and by that I mean that the balance of power or between the state and national governments has shifted dramatically. Of course, early on in our nation's history, the states were not really populated. Most businesses were regional, local or regional businesses, and it was there were relatively few major problems that arose that required national government intervention. Uh, so the states had the most power. Now, the first era of federalism from 1789 to 1835 is what we'll call martial federalism, and it's named that because the Chief Justice of the U.S. Supreme Court during this time was John Marshall, and he was a Federalist. And as I said, the states had the most power, and of course, Federalists believed in a strong national government. So he used his power as Chief Justice of the Supreme Court to somewhat shift the balance of power away from the states and more towards the national government. And he did it in such Supreme Court cases as Marbury versus Madison, which we'll talk about more when we talk about the judiciary, McCulloch versus Maryland, which is called the National Bank case. Basically, stated that the states cannot tax the national government, and it also set the precedent for the necessary and proper clause. Gibbons versus Ogden, which shifted the power to regulate interstate commerce more to the national government, and then Barron versus Baltimore, which stated that at this point at least, the Bill of Rights only applied to the national government and not to the states. Uh, so Marshall, in these court cases, and just for testing purposes, know which court cases fall under martial federalism, and we will talk more about those cases later in the semester. Uh, Also, you might do a quick Google on all of those cases, because it's interesting to know, you know, the stories behind them and the impact they had on our government and legal system. Dual federalism, 1835 to 1863. Roger Taney is the Chief Justice of the Supreme Court, and he is a states' rights Maryland slave owner. So he is going to use his power as Chief Justice to shift power back to the states if possible. And he does this through Supreme Court decisions, including the Dred Scott decision. He believed in a separate and equally powerful levels of government. He felt like under martial federalism that the national government had become too powerful, and so he believed that the states should and federal government should have equal power, therefore to balance them and to check each other equally. Dred Scott decision came out of dual federalism. He in the Dred Scott decision, basically Taney in the Supreme Court ruled that individual slave owners could take their slaves anywhere in the United States they wanted to, regardless of the laws made by the national government, which outlawed slavery, laws made in the Missouri Compromise of 1820. And the Dred Scott decision was a decision that one of the events that led to the Civil War. Also, the crisis of nullification came up, and this idea during the Taney court period, uh, southern states, specifically slave states, began to argue for this power of nullification, or the right to declare national law, a state's right to declare national law unconstitutional. Starting in 1863, which basically is the towards the end of the Civil War, up through 1913, we enter an era called transformative federalism. The national government becomes much more involved in certain aspects, including determining how states treat their citizens as far as citizenship rights. You have the Civil War amendments of this time, the 13th Amendment, which outlawed slavery, the 14th Amendment, which guaranteed equal protection of the laws and due process of laws for all citizens, um, and the 15th Amendment, which uh, attempted to give uh, all men the right to vote, regardless of race, color, or previous condition of servitude. Of course, during this time too, the national government, with the rise of the railroads and the steel companies and these big, huge monopolies, oil and gas companies, the Interstate Commerce Act created the Interstate Commerce Commission, which allowed the national government to regulate these businesses. In the past, the states had basically regulated most all businesses, including the railroads, including the large industries. Yet those industries got so big and so powerful that it became impossible for the states to regulate them properly. And so the national government had to create the Interstate Commerce Act and the Interstate Commerce Commission to begin regulating them. And they began, especially with Teddy Roosevelt, but it even began before that, with antitrust legislation, um, which basically prevented trying to prevent monopolies, trying to prevent corporations from dominating entire industries. Um, from transformative federalism, we go to cooperative federalism, 1913 to 1964, in which we see the government. This is the era in which the government just expands massively due to, you know, events somewhat beyond their control and really necessary in a lot of ways. 16th Amendment provided the national government the power to tax income. And then the 17th Amendment, direct election of senators by the people. Prior to this, the state legislatures elected their U.S. senators. Now the people will elect those senators. The Great Depression uh, hits during this era of cooperative federalism. Of course, Franklin Delano Roosevelt, the President Roosevelt, establishes the New Deal as a way to uh, alleviate the problems of the Great Depression. Of course, the New Deal is a huge expansion of national government power and scope, creating agencies, many different agencies to help put people back to work. And it was and many of those uh, acts of the New Deal were declared unconstitutional and had to be reworked in order to match up with existing law. But just know that it was during the Great Depression and the New Deal that the scope of the government increased dramatically with regard to how it interacted with the states in and supplying money and grants and to the states in order to put people to work to alleviate the New Deal. World War II, of course, greatly expanded the power of the national government to uh, dictate to all the industries what they would produce and how much they would produce, force them to transition their factories from peacetime production of cars or uh, whatever uh, to tanks and planes to fight to help the war effort. And most of this money uh, that was given to the states to help alleviate the Great Depression were what's called federal grants and aid, which is basically money given to the states saying, "Here, spend this money to build hospitals or build roads or build schools or build a dam." or whatever. Just the whole point was to put people to work and get money back into the economy. And then starting in 1964 with the election of Lyndon B. Johnson to the presidency, uh, you see an era of centralized federalism where previously in cooperative federalism, the national government attempted to solve specific problems in specific states um, with certain categorical grants that were and that would be determined, by the state and the government working together. Well, in centralized federalism, President Johnson saw some national problems that he wanted to alleviate, and he wanted to address that were a problem in every state. And these included poverty, discrimination, consumer protection, and pollution. And so Lyndon Johnson established his what he called the Great Society, which was an attempt by the centralized government. That's why it's called centralized federalism. The central government or the national government to help to use their power to solve many of these problems. Uh, and some of the programs that came out of um, the centralized federalism era were Medicare, which is a government funded health care for elderly people, Medicaid, government funded health care for the poor and disabled, and then Head Start, which is a program that provides preschool education for children who, in order to help them be ready to start school, they may come from a disadvantaged background and don't that doesn't provide them the skills and the education necessary in the infant and toddler years to prepare them for public school. Gives that This program helps give them a head start and gets them on level with kids from more advantageous backgrounds. Um, then, starting in 1980 with Ronald Reagan elected as president, we enter an era of devolving federalism where they're trying to roll back the power of the central government, the power of the national government in its relations with the states, rolling back national influence, a shift from categorical grants, which specifically told the states what they could do with national money, to block grants, which are basically big chunks of money, and overall less money than if you add up all the categorical grants, overall less money, but the states in block grants can do with the money and spend the money how they see fit, and giving more administrative power to the states with regard to how to implement programs. And then, starting in 2001 to the present, we are in an era of what I like to call coercive federalism. It's post 9/11, of course, post terrorism, post war on terror, or as we it encompasses the war on terror. You see a dramatic increase in a national security state. It's much like central federalism, except the priorities are not to end poverty, discrimination, and consumer protection. Now the priority and the power of the national government is laser-like focused on security and dictating to the states how they must respond to the security demands of the national government. Um, that includes the USA Patriot Act. Uh, Now, also part of course of federalism is the preemption of state power over educational policy, which we talked a little bit about earlier. That in the past the states had the power to determine, teacher qualifications and dictate what requirements there were for graduating high school and moving up. But now the national government, with No Child Left Behind and their standardized testing, has national government has taken over that. Department of Homeland Security, which was a new government program and the greatest expansion of national power or the bureaucracy since Franklin Roosevelt and the New Deal, basically placed many different agencies that existed prior to 9/11 as independent agencies and put them under the umbrella of one giant agency called the Department of Homeland Security. And then, of course, as far as this security state that we live in now, there have been leaks and stories about the expanded surveillance which most people argue is unconstitutional and violates the Fourth Amendment protection of unreasonable searches and seizures. Of course, this what I would call illegal expanded surveillance was initially carried about by the Bush administration, but it has been extended and continued by the Obama administration. So, for testing purposes, I would ask you to know the chronological order of those eras of federalism and kind of know what happens within each era. What's the primary important things that define those eras of federalism?